Hi, I'm Larry Hasparkin. I wanted to address an issue to tell you on April 24th, 2013, I filed a written complaint with the state's attorney that Rodney Copas and Clifton L. Larson illegally accessed grant expenditures of the Iroquois County Public Health Department. After the last board meeting, when I presented this information, the reporter asked Copas what I meant, and he stated he didn't know what I was talking about. I'm going to clarify exactly what I was talking about because I never want Copas to be confused what I mean when I talk about him or to him. On February 28, 2013, Copas issued a statement to the Paxton Record. In it, he mentioned checks, gift cards to Michael's Pizza, Casey's, Walmart, Dirt Cycle, Curves, and Dick's Sporting Goods. These are all expenditures from grants that were spent within the guidelines of the grants. His opinion about them is irrelevant, and they require no explanation because it was illegal to access them. According to the Auditor General's office, only the granting agency, Auditor General, or Attorney General can question them or audit them. These are only the ones he listed, not all they accessed, but these are enough to show that he illegally accessed grant expenditures. My second statement is to address the article in May 10th, issue of the Times-Republic. Copas again used two of his favorite tactics in this article, to shift blame to others and give a diversionary statement to take the attention from himself. He blamed Susan W. Wynn Vince to be the cause of the issues that the county is now dealing with. The state's attorney said the solar panels were a non-issue. The Attorney General said the whole thing with the health department was a non-issue. Let there be no mistake, the only person responsible for these issues is Copas. $15,000. Is that the free thing we were supposed to get? $15,000 mentioned in the article is the only tip of the iceberg. Thousands of dollars in lost man hours to assist and comply with Larson's request. Thousands of dollars in lost man hours to comply with the watchdog group that Copas brought to our county. Thousands of dollars yet to be lost in man hours to comply with their further request. And thousands of dollars in man hours to be used by two state's attorneys to defend our health department in lawsuits from the watchdog group that Copas brought to our county. You add all these together, and you'll find out Iroquois County taxpayers paid $30,000 plus to finance Copas' personal vendetta against the administrator of the health department. He will deny that he brought the watchdog group here, and he will deny that it was and still is a personal vendetta. Using this watchdog group is his way of continued harassment of the health department, and they will only stop if he tells them to. He was able to accomplish all this because this county board was an enabler. You enabled him. It's time for the board to start thinking for itself. Once before I asked you to analyze and look for the truth in his statements. I again ask you that because you will again shift blame, make denials, and make diversionary statements after hearing what I have said. This board has to tell Copas to call off the watchdog group that he brought to our county and stop the harassment of the health department and stop wasting our tax dollars through lost man hours. If I were an employee of the health department, I'd be talking to a good attorney, and I'd be using terms like libel, defamation, and slander. Again, I say the only person responsible for the issues now faced in Iroquois County is Copas. The county board needs to realize that when Copas speaks, it's not like you're hearing words from the burning bush.
John Kraft. I hadn't planned on talking this morning, however. I just want to clarify accessing grant expenditures. The state constitution, the Illinois Freedom of Information Act, and the Local Government Records Act require that all expenditures of public funds be open to the public. That means anybody can look at them, not just Mr. Copas or me, anybody in the audience can do a FOIA request and ask for a copy of it. And I believe that concludes what I have to say.
Good morning. My name is Kirk Allen. I'm with the Iroquois County Watchdogs. Contrary to a statement I just heard, like I said the last time I was here, 3 different people asked us to look into some matters. And they weren't inside this county. And it's interesting to hear claims. I'll stand here and I will tell you before God and country, prove me wrong, and I'll stand here and I will apologize and I will correct anything that is incorrect. I challenge you to disprove me. Prove me wrong with the information and the facts. And I'll start with yesterday's public hearing. Mr. Devine, you'll appreciate where this is going to go. This is a stack of documents we got that were grants. We were told, I asked for 3 things: grant applications, copy of all grants received, copy of all grant compliance documents, and copy of time cards. If I understand correctly from yesterday, the only thing we did not give was grant compliance documents because there was some confusion. This one page, this one grant, is the only one that has a grant application. Everything else is grant agreements. There's not one grant application anywhere in that. Therefore, the information presented to the courts yesterday was not only less than truthful, I believe that you put your state's attorney in a position where he presented something to the court that wasn't fully true. February 4th of this year, we were contacted by 3 people begging for help to expose what they knew to be wrong within the Fort Iroquois Public Health Department. We ran our first article on the red flags we saw on March 18th. In just over 10 days from our first public exposure of illegal expenditures by your health department, I was presented with not one, but 2 separate letters threatening both John and myself with defamation lawsuits for the articles we published. We are used to such threats and know each time it happens we must dig deeper to expose what they're so afraid of getting out in the public eye. We now even have members of the health department that think a citizen in this country should be required to have permits or special certifications to get public records. Even worse, Dr. Bucker believes that if the requests are truly in the public's interest, then people from the county would be requesting it and turning it over to the proper authorities. These attitudes don't surprise me, considering only one of those members on that board had complied with the Open Meetings Act training requirement. I'm here to tell you it is the very people from within that department that are begging this information to get out, as they are afraid to speak up because of the strong-arm tactics. Not all that different than threatening us, which, by the way, won't work and didn't work. Thomas Jefferson's first inaugural address in 1801, he stated, "The will of the people is the only legitimate foundation of our government, and to protect its free expression should be our first object." I will not be silenced, nor should anyone else. It is we the people that must have the courage to ask the tough questions and the strength to hold our public officials accountable. When we fail to hold wrongdoing accountable, we are condoning a lawless society. The strength of the Constitution lies entirely in the determination of each citizen to defend it. Only if every single citizen feels duty-bound to do his share in this defense are the constitutional rights secured. Why is that significant? Because each and every one of you elected and appointed officials took an oath to uphold our Constitution. The taking of that oath was the assurance to the public that you serve, that you're a man or a woman of your word. The public placed their trust in you. When you violate that trust, you allow the law to be ignored and are contributing to the decay of our society. Having spent a career in the military and traveled all over the world, I can say that this country is truly the greatest nation on earth. I see that greatness being ignored, taken for granted, and basically spit on when the level of wrongdoing we have exposed in the Fort Iroquois Public Health Department is ignored, justified, or thrown off to outside agencies. You can attack me. I welcome it. The messenger, that's who I am. You can attack me all day long, but that will not fix the problem. I challenge each and every one of you to prove our reporting wrong. Have an open, honest discussion of the facts and be willing to be intellectually honest with yourself. Take the time to read the laws. Apply them to each and every issue raised. Don't rely on some outside agency to do your job or some unfounded opinion, such as the opinion that nobody has the right to look at the financial expenditures of a grant. Everybody does. That's in our Constitution. Your health department administrator has placed a hefty financial burden on the public, and I believe you are only beginning to see a trickle of what is coming. He hired a private attorney to represent what I understand is a workplace harassment case. Doing so means if you lose that case, which I suspect you will, the county is on the hook and not your insurance company. The hiring of that attorney for such matters is well outside the scope of the law. That violation has been fixed thanks to your state's attorney, which, by the way, last night in regards to the solar panel subject, it's been put on record now, according to Mr. Corbett, it was Jim Devine that said you don't have to put it out for bid. He stated that 3 times in last night's meeting. If that's the case, then I must simply ask the question. If he told him you don't have to put it out for bid, why did you? He got one bid, and the one bid that he got legally didn't get the bid. Mr. Corbett is authorized using taxpayer money to provide money to a private foundation to include a lending agreement similar to what you find with a bank. The agent of record for that private foundation is the very person working for him on the county dime. Within days of our exposing that operation, the foundation paid the money back, which was well past due according to the loan agreements. Were you aware he was using your tax dollars to run the lending institution? How many other things are they paying for that they shouldn't be? You may recall Mr. Corbett justifying his spending money on promotional items like fly swatters and calendars with the claim that that's what the grant was for. We'll find out when I finish going through that. That admission is on video and was aired on TV. When the law clearly forbids such expenditures for promotional items, are you going to hold him accountable to the law he broke, or just ignore it? And before one of his defenders tried to make the claim he didn't know, rest assured he knew, as did several others in his office, because it was from within his own office that it was uncovered. All we did was confirm the statute and expose it to the public. From illegal solar panel purchases to violating the public's right to records, it's clear you have an administrator that needs to be held accountable. I understand sitting here and hearing these words from a total stranger can be disturbing and may even outright upset you. I can appreciate that. It's going to take all of us to stand up and ask the tough questions and be willing to realize we have been taxed to the point these people are seeking ways to spend it more often than not on items that have nothing to do with the original purpose of the health department. If the law is silent, they can't do it. Each and every power is outlined by our Constitution and state statutes. Just asking the simple question, where in the statute does it allow the spending of money on this or that? That answer will shock you. Shock you because a fair share of your tax dollars are being spent well outside the scope of authority provided by our laws. We were never taught to ask that question. Many of us have stepped up to serve the public for a lot of different reasons, and I commend all of you for that service. However, if we don't know the limits of our own laws, then there will be no limits to the spending and raising of your taxes. I'm asking you good people to dig deep into your heart and ask the tough questions and hold people accountable when you know they're doing wrong. Accountable means to have them prosecuted in many cases. When you simply allow them to move on to another job to avoid embarrassments that happen under your watch, they end up doing the same thing to some other taxpayer body. Don't pass the buck. How you deal with the challenges you face determines your worth as a human being, in my opinion. Prove to the good people of this county that you won't tolerate the misuse of our tax dollars. And I want to reiterate, I'm here because people ask from outside this county, sir, and to everyone here.
I have a question.
I have the floor, sir. In regards to that, we don't answer to anybody. I answer to my God. And I will continue to do what I'm doing. And I beg of you to prove me wrong. And if you can prove me wrong, I will stand before here and I will apologize and correct whatever that wrong may be. Everything that we publish is with documents to back it up, with state statutes to back it up. Prove me wrong. That's all I ask. Thank you.
Mr. Miller?
Well, actually, when I asked for an opportunity to speak, that was before Mr. Devine came in, and I would prefer to listen to his pronouncements now that he's had a chance to study the Illinois Livestock Management Facilities Act.
Yeah, I have. Comment on that? Yeah, sure. I don't know about studying as reading it, but it's a pretty clear statute in regard to what happens when you have livestock operations of more than 1,000 animals. And it is governed by the Illinois Department of Agriculture, and there is a statute that defines it, deals with the details, and also talks about how the county is involved in that process. And as I read it, this is a statute that actually began in 1999 with a couple of years where there have been amendments. And basically it says within 7 days after receiving a form giving notice of intent to construct a new livestock management facility, waste handling facility serving 1,000 or more animal units, and it goes on to describe livestock waste handling facility and so forth. The department, which is the Department of Agriculture, shall send a copy of the notice form to the county board of the county in which the facility is to be located, and shall publish a public notice in the newspaper of general circulation within the county. And after receiving a copy of the notice from the department, the county board may, at its discretion and within 30 days after receipt of the notice, request that the department conduct an informational meeting concerning the proposed construction that is the subject in this particular section dealing with livestock operations. In addition, during the county's 30-day review period, county residents may petition the county board of the county where the proposed new facility will be located to request that the department conduct an informational meeting. And when petitioned by 75 or more of the county's residents who are registered voters, the county board shall request that the department conduct an informational meeting. So really, we need to receive some specific information from the Department of Agriculture that there is a livestock operation intending to be built that houses 1,000 or more animals. So until we get that, we're really just in the rumor stage of sorts.
The only question then that I have in regards to that is on the issuance of the building permit, we should not issue one until we receive that.
That would be my recommendation, yeah. Having read this and knowing that we're to receive information from the Department of Agriculture.
They've applied for a permit and they've been assigned a NOITC number. So that part is in the works, so it's more than rumor.
Okay, well, and I think our next step should be to contact the Department of Agriculture to ask why the county board hasn't been notified of a facility that's being intended to be built with 1,000 or more cattle.
Well, I would encourage the county board to embrace the process that says the county board may, that you go ahead and embrace the 5-step process that we need to go through, because the residents from Ridgeland Township are not happy campers at all. And I think that the county board would want to go ahead and embrace the process. Okay, if we don't prevail, fine, we went through the process. But if you don't go through the process and they build a big confinement operation, you're going to have unhappy voters. It's as simple as that.
Yeah, policy decision needs to be followed through by the county board, but at least we can make a contact with the Illinois Department of Agriculture to see where they're at in the process, what information they have on the confinement operation.
Well, Mr. Perkinson took a lot for granted here, because in his application to construct this facility, he has said the construction would start May 1st. Of course, he's running a little behind on that. That's when they said they would start. So apparently they were banking on the fact that we may not go through the process. Hopefully we do.
We'll see that it gets looked into at the very least, and I'm sure the county board's going to be interested as to what information they can obtain. I'm not going to speak for the county board. I'm sure you guys know what you want to do, but that would be my guess. Any other questions on this? That's pretty much the procedure. It's all governed by statute. So set out in the law what has to happen or what needs to happen. So we'll see that it gets followed through.
And we have not received any notice at the county level at this point from Any other public comments? Motion to approve the minutes from the April 9th, 2013 recess session. John Sure, second. All in favor? Aye. Opposed, same sign. Motion to approve payroll. Mr. Alt. Any questions on the payroll? Roll call vote.
Anderson.
Yes.
Barons.
Yes.
Bills.
Yes.
Crow.
Yes.
Curtis.
Yes.
Hanson.
Yes.
Hiles.
Yes.
Crumweedy.
Yes.
Raymond.
Yes.
Schmidt.
Yes.
Schultz.
Yes.
Shure.
Yes.
Sticknot.
Yes.
Bosmer. Whitlow.
Yes.
Van Bent. Newmall.
Yes.
Alt.
Yes. Couple of things on Chairman's comments today. I'm going to have probably some things that some don't like to hear and some things that some do like to hear. I do want to, Glory Ritz is hiding in the back corner. I just want to say thanks for the 31 years of being the township clerk in Douglas Township. She did a hell of a job. Carl Brown was supposed to be here today. This would be probably Carl's last meeting. I don't know if he's not going to make it or not.
He's
But
not gonna make it.
he's not making it, okay?
No, he's not gonna make it.
Okay, well, Carl Brown is retiring at the end of this month?
Yes.
Yeah.
And he did have a message for Kevin, but he's not here, is he? Okay. Kevin promised him something he's planning on still collecting.
I'm here.
Oh, there you are!
Okay. Over the last several months, we have had concerns about Fort Iroquois Public Health Department. Fort Iroquois Public Health, again, is part of the Iroquois County Board. For 20-some years, since 1990, that was about the last time there was a meeting of the joint two county boards where they had oversight. So the Public Health Board has been off on its own for this time, about 20-some years now, with little or no oversight by the two county boards. That's our fault. That's the two county boards' fault. There are still questions that are going to be answered sooner than later. We're still in the process. Unfortunately, it's not a nice process. It's not easy. But we owe it to the taxpayers to understand and make sure that the judgments and the decisions that are made are correct. We're going to just touch on briefly on some issues. And then going forward, at some point, we will have to make some decisions. The Indiana deal, when you start looking at that, and you look at the cost involved, we spent probably close right now at around $10,000 in taxpayer money by the time you pay the rent and the utilities and the insurance, and we signed a contract for a year on the building. We signed a contract with a consulting firm. We had a contract with a doctor, which we got out of, that we didn't pay it. We have utilities. So we have all these costs. And what's amazing about that whole thing was not one attorney, and they had four attorneys at that time, and not one of them was asked a question about moving to Indiana. We have an agreement again between the two counties that prohibits anything outside of Fort and Iroquois County. That's our agreement. If you want to change that agreement, you have to come back here and do it here, not willy-nilly. Let's talk about the attorney side of things. Until 1/1 of 2012, public health under Illinois law did not have the authority to hire outside counsel. After 1/1 of 12, the law reads, the Board of Health of a multi-county health department may hire attorneys to represent and advise the department concerning matters that are not within the exclusive jurisdiction of the state's attorneys of one of the counties that created the department. There's a very definite limit to the authority to hire outside counsel at will. We have this human rights lawsuit that was filed against the Public Health Department probably close to 4 years ago now. It's in court in Chicago. The problem with that is our insurance company, which we have errors and admissions for, was never notified. I don't know anything about it. We go hire a private attorney to represent the Public Health Department. What does that in turn do? If there is a judgment or a settlement that comes directly from the coffers, not the insurance company, they're not going to pay a dime. Randy Schultz sat back here at Finance or P&P Finance and told us they will not pay anything. So we're paying insurance, we're paying attorneys. We have a state's attorney who's paid by the taxpayers already who wasn't asked anything about it. It's not good. We have spent tens of thousands of dollars over the last 5 years paying attorneys without legal authority. Bookkeeping and accounting. In the last 2 years, and this is just to tell you who's on the payroll in the bookkeeping and accounting side of things. We have a bookkeeper, then we have paid Kelly Cox and Painter, we've paid Rita Fink, who's a CPA, Smith, Colling and Ohm, and Clifton Larson Allen. We have Clifton Larson Allen is our audit firm that goes in once a year. When they come here to do our audit, they go down there and do that audit as well. And they do that because that's part of Iroquois County. So they go down and do that. But before they get there, they bring in another audit firm to help them clean up the books. Well, maybe we're not doing the job right to begin with. We shouldn't have to do that. Last 2 years, $30,000 on a web page. And yet we can't post the salaries as required by law over $75,000. They're required to be posted. We got a $30,000 investment in a web page, but we don't post the salaries as required by law. The county, we do it here. The foundation. The problem with the foundation is, you take a foundation, we created a nonprofit foundation using tax dollars. Now the money got paid back. The problem is, here's the deal. You've got the Regulation Authority of Public Health. Where are they raising the money? They're going to the food industry that they regulate to raise money for their foundation. Is that not a conflict? Don't we see a conflict in that? I mean, how do you justify that? You can't, it's a conflict. The solar panels, $128,000. No public input, none. There was no meeting like this for you to come. Mr. Hasbargen likes to come and voice his opinion, and that's great. But there was no public meeting for anyone to voice any concern. And we spent $128,000 of our money on that project. No public bid opening. We have special meetings sometimes because we get in a bind, we got to have a bid opening. We call special meetings to do that. Does it cost the taxpayers sometimes? Yeah. But is it in their best interest? Absolutely. It's open, honest government. The second, when they awarded the contract, all of the documents that exist, that were never public, there was no public meeting, all the documents that exist say that they signed an agreement with Day and Night Solar. So you ask for the contract with Day and Night Solar, it doesn't exist. CMS Renewables got the money. That's an employee and her husband that own CMS Renewables. They got the money. There's a law called the Local Government Energy Conservation Act, and it does apply here. There are requirements that you have to follow, which they were not. There was no budget. We're required to budget. We have line items that have $500 in them. They spent $128,000. No budget. According to the newspaper ad, The bids were only accepted online. Anybody with any common sense understands the guy on the receiving end can see your bid. There's no way to protect that bid. Is that a fair and honest bidding system? If you want your government run that way, then I suppose you support what they've done. The only bid submitted online was Angel Wind Energy from Largo, the local contractor. That was the only bid. 3 hours later, Day and Night Solar submitted a faxed bid, not as required by their notice in the paper. How much more convoluted do you need to get this to understand this was a Shanghai job? I'm going to show you why they're telling fibs now, too. On July 18th, the Fort Iroquois Public Health Board meeting, it says in their minutes that on July 1, there was a contract signed with Day and Night Solar. That's what their minutes say. And how do I believe that to be exactly true? Because, now that didn't exist, they say now. Here's the deal, right here, this document here. It says required actions of the board. Every public health board meeting that's conducted, the motions are pre-assembled. So that all you have to do is fill in the person that made the motion and the second of the motion. Every one of these board meetings. So now explain to me, if you say that document don't exist now, explain to me why on July the 18th, the board would approve a pre-printed document that says there's a contract signed on July 1 and it didn't exist. Is there any rationale there? The other deal is, Mrs. Clark said, CMS is the installation arm of Day and Night Solar. Does anyone pay the subcontractor all the money and the general contractor zero? If you believe that, just wait, because they're going to be sending each one of you a check for $1 million. There's an email about the solar system. It's here. I have it here in front of me. And it says they hooked up the solar system to the internet so they can view what it produces. Yet they declined. They said you can't do that. So either the taxpayers paid for something that we didn't get, or they, again, are not telling the truth on for you. Pay raises. I was told that there weren't any pay raises the last little bit because things are terrible. One pay raise was given in a 3-year period. The pay went up 54%. I don't know, that seems a little exorbitant to me. You have to do the figuring yourself. They're looking at last year to the year before, everyone that I looked at, and you can get online and look at all the pay of government officials, everybody made more money than they made the year before. So I don't know where the not getting a pay raise thing came from. Overdraft, 2/29 of 2013. The bank statements show $88,000 in overdrafts by the Public Health Department. You know, Mindy sits back there and she knows how we struggled here in Iroquois County for years, but we never did that. We never sent out checks that we didn't cover. And to think that's an acceptable practice, they say, well, the bank waived the charges. It was $612. The bank waived the fee. Well, tally-ho. The point is it shouldn't happen at all. If you've got people that are managing and running the thing right, it wouldn't happen at all. What do you think would happen to you if you wrote a check for $88,000 that wasn't good? The bylaws. Let's talk about the bylaws just a quick second. Bylaws of the public health are contrary to state statutes. The bylaws of public health say 4 of 8 is a quorum. That's what the bylaws say. The law says it's 5, not 4. They say they can call a meeting, special meeting, in 24 hours. That's in the bylaws. That's not correct. It's 48 hours by law. They say it takes 2/3 to change the bylaws. It's not correct. It's a simple majority. You can't get, I mean, you just can't run this way. It's not good. I'm going to talk a little bit else here too. Pantograph. I went to GIE, which is an insurance company. I went down to Bloomington, spent the night. The newspaper was there, and this is March 21st. Health rankings for the state of Illinois. While we're off in Indiana trying to strum up business, and we're installing solar panels, and we're doing all these things that really don't have a long-term effect on Iroquois and Ford public health issues, our rankings dropped. We was in Iroquois County at 43 in the state. We dropped to 68. Ford County was at 11, and they dropped to 34. Right here in the Pantograph. We're dropping, and we're the most expensive. Look at our neighbors. I've told you this before. Look at our neighbors. Look at the cost of our neighbors. We're paying $18.30 for every man, woman, and child in this county, in Ford County. That's our cost. Our neighbors are in the $3 to $5 range. Are we getting that much more? I don't know. I think we're spending our money in Indiana and on solar panels. Not a proven track record. I don't have a personal agenda at all. This is business. This is faulty government business. If you think it's legitimate to conduct business, I've asked Mr. Devine, would we be allowed to have award a contract with $128,000 without a meeting or a bid? Mr. Devine would hang us out to dry. We all know that. But yet it seems to be defended and accepted by some around. There are good people in the public health department. There are some that are not so good. There are some that are self-serving, and we will be giving you more information on that as it comes around. Committee changes. Mr. Watts is not here today. I talked to Adam, Kyle. We're going to move Mr. Watts from the highway department to the zoning. And we'd like